Now, good. So that play for a minute while we get ready to go live. I think I need to do something about it. I can read it from right there. I think it's on. Make sure. I wish I could find it. I have to use this to read it because I don't know where it's at. There she is. Let me get rid of this music and we'll be ready to move on. Hey girl, let me get rid of this.
Hey girl.
Okay, come on, fix this. Oh, he's so loud. I don't know why it gets like that, but anyway. All right, good. All right, we are actually live, so just want to let you know that.
Okay.
Let me take this off. Just put my little fair use out there. I'm sure everybody knows we're using this under fair use. There you go. No, oh, we're both on. Good. All right, good. So, yeah, I was reading along today, and I was like, oh my God, I didn't know because I didn't see anybody talking about this, and I discovered that, this was out there. I was like, oh, wait a minute, sorry. All right, good. Hang on. Anyway, I discovered this out there. I thought, oh God, we got to go talk about it. But I couldn't decide if I wanted to do it tonight or tomorrow night. I really couldn't. And then I said, you know what? I think we're just going to jump on there and do it tonight. What the hell? Let's just do it tonight and talk about it. So I threw it out there. I put our advertisement out there. But anyway.
Yeah, I just Googled it. I didn't even know anything about it until you said something. I just Googled it.
Shocking,
I saw
isn't
the reason. I saw the reason, and I was like, "Oh, good Lord, have mercy."
Yeah, I mean, we kind of people have talked about that once before, and I did listen to the actual appeal. I heard the arguments myself, and I listened to both sides. And at this point, I'm going to tell you, I don't know because it is iffy. Because I do remember the trial, and I do remember them when they were going on about. I mean, it took a long time to get jurors. We know that, and in one sense, it almost seems like that attorney did this on purpose because he knew this would be something they could appeal about. But then on the other hand, you got to think to yourself, do attorneys really think that far out? Because they know they're not going to get the appeal. In most cases, they don't get to do the appeal themselves. So would they really think that far out? I don't know.
Right.
I'm not sure. Kind of interesting.
But they
Found
discussed all this. They discussed all this when they were choosing the jury,
that's correct. They did,
and the judge
and you had
ruled against it. The judge basically said there's no conflict.
right. That's right. And they had, they had preemptive strikes. They had all these strikes that were available to use. And the question is, did they intentionally leave this person on the jury knowing that at some point they would be able to file an appeal on it? That's the question.
Right.
Is this what happened? Do attorneys think that far ahead? I don't know. Yes, maybe, maybe. I'm not sure if they do or they don't. But I thought I'm thinking it is because the attorney for the state, when I listened to her argument, that's basically what she said. That's basically what she said was, oh, well, he did this on purpose for appeal purposes only because he knew he could have struck
Mm,
the person at any time. Okay. So
right.
that's kind of what's going on here. So what I'm going to do first is I'm going to pull this up over here. Let me pull this up. Get myself back
Well,
over here on
all it's going to be
StreamYard.
is a waste of money in the end because they'll go back to retrial and it'll all come back out where she admitted to killing him. I mean, she admitted it. So how they can retry it, but the outcome's going to be the same. All it is going to do is just cost money.
But what if for some reason this causes some evidence to not come in into the trial? Because of this error, what if some evidence is not allowed to come into the trial? And what if it changed it? What if, what if all of a sudden she got an overturned and then they offered her some kind of some kind of a deal, to go ahead and take a
I
guilty
mean,
without having to retry it because it's expensive,
do
you
you
know?
do you think that her confession would be thrown out though?
See, that's the thing. I'm not sure about that. This a lot. This brings up a lot of questions. A lot of answers need to be had. This is bad. This is bad news.
Yeah.
I'm really hoping that we don't end up with her getting a whole new trial out of it, but we never know.
Oh God.
Because when I actually play the appeal hearing, you'll be going, oh shit. But hang on, let me read this
Hmm.
first. We'll talk about this one first. Oh, come on. Here we go. Oh, it was a beautiful day today here. Tomorrow's the big old Super Bowl. Who's for who?
Was that?
What's tomorrow? So, I don't know if you're interested in
Yeah, it was
football or
like
not, but
80 something degrees here. It was warm.
nice,
I've always
nice.
tried to understand football. I never could quite grasp it.
Me neither. I just didn't listen because my husband's excited about it. So, that's what
Right.
that's what's going on.
Yeah. Yeah.
Oh, come on, thing. I just had this. It makes me so mad. It is uh KD. Let me get this here. KDVT. Mm, can't spell worth a shit.
I
All
wonder.
right.
God, I feel sorry for Landon and damn, I lost my train of thought. What is the dad's
Al.
name?
Al.
Al. God,
Me too,
that
because
went out of my
this would
brain.
yeah, I know. It doesn't bring up a horrible, horrible
Oh,
situation if this has to happen again.
6 years later, oh my God, to
Yeah,
relive everything, that would just be horrible. Horrible.
this is called well, maybe I can just pull it up right here. You guys hang on just a bit. I don't want to mess up nothing. Okay, it's right there, but I'm trying to let me split the screen so I can actually read it. And I just don't want to mess this up. You know, I get all scared about that.
I
Let's
know.
see. It's right here. All right, now, so listen to this. This is from, okay, why am I getting that noise? Why am I getting that noise?
I turned my TV on. I turned it down.
Okay, all right. Um,
I turned us
this
on
is
the
from
TV.
January the 27th. Denver. The woman found guilty of killing her stepson in 2020 is trying to appeal her conviction. And the latest step in this process came Tuesday with oral arguments presented in front of the Colorado Court of Appeal judges. Now, the one thing about this, she did not get her wish. She was not in attendance. Thank you. I didn't want her to get to go to
Right?
court that day. Remember when in those phone calls she talked about it and talked about it like, I'm going to be in the courtroom. I'm going to be able to see it. They're going to bring me over. I'm going to get to see it. And remember, her girlfriend thought, oh, I'll get to see you when you come over to the actual jail
Right.
so you can
Yeah.
go to your appeals hearing. Well, that didn't happen. So Letecia
Thank
Stauch,
God.
42, was convicted in May of 23 of stabbing her stepson, 11-year-old Gannon, God rest his soul, that poor baby, 18 times, beating him with an unknown blunt object, and shooting him once in the head at their home in an unincorporated El Paso County, southeast of Colorado Springs. She was sentenced to 2 life sentences without parole, 12 years in prison for tampering with deceased human body and 18 months for tampering with physical evidence. Court records show she filed an appeal after the conviction, but oral arguments would not come until Tuesday when both parties addressed a panel of 3 Colorado Court of Appeal judges. The oral arguments, and here's the concerns. Concerns were over a juror should have been allowed to sit on the case, took center stage during this argument. During jury selection, it was learned that one of the jurors had a son-in-law employed as a deputy district attorney in the El Paso County District Attorney's Office, something the defense initially objected to. This is what Eric Sampler is saying. Despite this, the juror served as an alternate, later going on to fill the role of a juror who was dismissed during the trial. The court was presented with facts necessary to establish the statutory relationship, and the jurors served. The defense wrote in a May 24th brief, this is a structural error requiring reversal of the conviction. See, she's thought in her mind this whole time, I'm getting out, I'm getting out, I'm getting out. Remember all the times she said that? Yeah. Sure do. Prosecutors at the time said juror had not said anything during questioning to show he had bias. Senior Assistant Attorney General Catherine Gillespie, who argued it on Tuesday. Gillespie argued that when the juror in question was moved from the alternate position to the defense, did not object. She questioned if this was a strategic plan to possibly have grounds for an appeal. Now, that is the question that I kind of have about this as well. Was this a strategic move by Tortellini? I call him Tortellini. That's not really his name, but that's what I call him.
Right.
Sampler denied that the decision not to object again was a plan for a later appeal, saying this was the best way to win an appeal is just to win at a trial instead. Well, if you won at the trial, you would not need an appeal. What kind of stupid shit was that? I'm just going to say it like that. I can't believe he even said that. I mean, that made no sense at all. You don't need to file an appeal and win the appeal if you won the trial. Okay, we know this. Sampler continues saying the fault falls on the trial judge for not knowing the law. Now, that upsets me because I love Judge Warner, and I know he ran that trial 100% knowing what the law was. I don't understand him making that comment. It was wrong on his part. The court got it wrong, he says. No decision on the appeal was made on Tuesday, but a ruling is to be expected at a later date. It usually takes 30 days, up to 30 days to get this. Stauch reported her stepson missing from their Lorison Ranch home in January of 2020. She killed Gannon in his bedroom and hid his body in a suitcase, according to the Post-Gazette. In the weeks that followed, Stauch seemingly tried to cover her tracks by telling a series of fictitious stories and hiding evidence. She was eventually arrested on March 2nd, 2020, in Myrtle Beach, South Carolina. Evidence in the 2023 trial showed that Stauch moved the suitcase containing Gannon's body from a basement storeroom to a parking lot. Oh, God, poor baby. And then to a wooded area near a lake, eventually throwing him off a bridge in Florida, where it was found on March 18th of 2020. On February 11th of 2022, Stauch pled not guilty to reason of insanity to 4 counts in connection with his murder. Stauch's defense didn't deny that she killed her stepson, but argued the killing happened during a psychotic breakdown. Now, let's talk about that for a second. If you're saying this happened during a psychotic breakdown, she's already admitted that she did it, and you're appealing her life sentence without appeal because of a juror? Think about this. This is ridiculous. I mean, yes, everybody deserves an appeal, and I guess when you're grabbing at straws and the only thing you can find to appeal on is this, think about that for a second. Now, I noticed that somebody had this document that they were not supposed to have because this is a sealed record. And I've tried every which way you can to get this document, okay? So what I found today was that somebody had this document and they were posting about it on YouTube. And I'm going to tell you what it says. These are the 3 issues that they filed their appeal on. The trial court's erroneous denial of a statutory required challenge for cause for a juror who ultimately served on the jury is structural error requiring a reversal. The trial court erred in failing to grant Ms. Stauch's motion to suppress the search of her iPhone 8 because the warrant was overbroad was overbroad and lacking in particularity as required by the Fourth Amendment. That was not even argued in the appeal. The trial court erred in allowing testimony about the defendant's prior manipulated behavior. Hey, Magic Star, good to see you, girl. Thanks for stopping in. We appreciate it. This is
Hey,
kind of
Magic Star.
interesting. So that is what their bitch is. But when they get into the appeals court, they only argue about the juror. So these other two situations must not have been important at all, right? So then it goes back and says, Stauch, okay, so her defense didn't deny that her stepson was killed. Stauch's trial began with jury selection on March the 20th and took 5 weeks to complete. She was found guilty and sentenced on May the 8th. Her civil lawsuit, Stauch challenged the conditions of her confinement in El Paso County Jail prior to being convicted. While incarcerated before her 2023 trial, Stauch filed a lawsuit against the county and the jail's medical and food providers. She claimed that were inappropriately labeling her food, violating the sanitary requirements of a kosher diet, and then delayed or denied her food in retaliation of her complaints. Stauch also alleges that the jail was not providing proper medical treatment for her. Now, if you remember back in some of these phone calls, she said she didn't need any medical treatment. She said she was not depressed and she was not on any type of medication. She was not, in other words, she was not crazy. But remember, she pretended to be crazy the whole time until she was convicted. All right. I'm starting to wonder though if the vampires that were coming into her cell were also going to see Lori Vallow and also going to see other people.
Yeah.
You know,
yeah.
like Ruby Frankie and all those folks. I wonder if they all saw the same set of vampires. Oh my goodness. Okay,
Yeah.
so
And
last
Gypsy.
night,
And Gypsy.
and
Nick.
Gypsy, I'm sorry. Yes, I wonder if Nick was actually the vampire that was going to see
Yeah.
Letecia.
Letecia. Yeah.
I wonder if it was. We need to ask Nick, right? God. So last night we actually did get to go see the brand new movie Dracula. Dracula, the love story, starring our guy from Texas. He's so cute, Caleb Landry Jones. I'm telling you, it was good. My husband said, I did not know. Yeah, my husband said, I did not know that Caleb could act because he sings and he plays all. He's very talented. Plays all kinds of instruments. I mean, he's quite a talented young man. So it was really good. But anyway, we'll get back to reading. Sorry, you know how I get sidetracked a little bit. The defendants moved to dismiss the lawsuit. According to the past Gazette coverage, but Stauch repeatedly failed to respond to the court filings. In August of 2024, an order by U.S. District Court Judge S. Cato Cruz decided to dismiss this lawsuit due to her failure to prosecute. Cruz cited Stauch's pattern of non-response and non-compliance with procedural rules. Okay, so that's how this happened. And now we're going to get over to the actual hearing. We're going to watch this hearing. So give me just a second. Ooh, that looks so big. I wonder why it's so big like that. Okay. Now let me get this set up so we can watch the hearing. This is the actual oral arguments as they took place on the 27th. So, wait a minute. Come on now. I got to pull them back up. Hang on. That's the Gazette. Oh, don't tell me it's threw me out. Let me get to the Colorado Court of Springs. Okay. Oh, I got to go right here and get it. Okay, sorry about that. This was January arguments. And this, okay, so this is like the docket. Hang on a minute. I got to close some of these. Hang on a second. There's the docket. Let me close this one. All right, let me come back over here to you guys. I have it open. I just need to play it. Oh, I think it's right here. There's the docket right there. Let me see what you see when I show this up. Okay, so the docket is right there. We're going to close that one out. I've got to get over to the actual broadcast. So, hang on. Oh, here it is. Now, let me make sure y'all can see it before I turn it on. No, you can't see it yet. I got to reshare the screen. Sorry, guys. Let's share the screen. I want to make sure I get it on the right thing. Share the screen. And it's going to be the live broadcast right here. Okay, there. I'm going to share the screen and I'm going to go start it. Okay, I'm going to turn it up so you can all hear it, okay? Ready? Because this is actually the actual arguments right here. There we go. I can't make it any larger. That's the only problem here. They're just kind of hanging out amongst themselves for a minute. Let me turn it up so we can see it. Here we go. Yeah. Whoops, that should be loud enough. All right, ready? Is it going? Come on. Oh yeah, they're moving around. All right, we'll let this start.
Cautious about sensitive information.
All right.
In particular relating to any
I wish you
minors.
could make it bigger.
Also, because we are recording the arguments today, we ask folks in the courtroom to turn your cell phones off. Apparently, silence is, or just turning them on silent is not enough. They can interfere with our recording equipment. So if you haven't done that yet, please go ahead and take care of that. Also, I understand that we've got hearing devices available at our bailiff's desk if anybody needs one. And also, we try to get names and pronouns right. If we mispronounce someone's name or misgender someone, we ask you just let us know and we'll get it right from then on. Does anyone have questions about procedures before we start with the first argument? Okay, great. We'll get that going then. So the first case we have on our docket today is 23 CA 1067, People versus Stauch. Counsel for the appellant, you may proceed.
Good morning, Your Honors. Eric Samler, attorney registration number 32349, here on behalf of the appellant. I would like to spend my time today talking about the juror issue. And I think the best place to start is with what's not in dispute. Under 1610-1031B, the trial court must sustain a challenge to a juror if that juror has a relationship within the third degree by marriage to any attorney of record or attorney engaged in the trial of the case. Under People v. McCrander, a 1992 case, the term attorney of record includes any deputy district attorney in the district attorney's office prosecuting the defendant, even though that district attorney may not have formally appeared or participated in the case. No one disputes that the jurors in question's son-in-law was an attorney in the El Paso County District Attorney's office at the time of voir dire, and the El Paso County District Attorney was prosecuting Ms. Stauch. No one disputes that the relationship of father-in-law to son-in-law is a relationship within the third degree by marriage. And no one disputes that under People v. Abu Natambu L, if a juror satisfies one of the grounds in 1610-1031 and the court erroneously denies a challenge for cause to that juror, and the juror ultimately deliberates, and if all peremptories are used, reversal is required.
Pardon me, counsel.
Mm-hmm.
Let us assume that we agree with you that there was an error here as far as denying the challenge for cause.
I wish you could make that bigger.
Let us further assume, though, that we want to take a look at the argument from the Attorney General's office that that has been waived. And I want to ask you a particular question about a particular part of the waiver argument.
Mm-hmm.
And this has to do with the fact of the waiver, that there is no waiver. Your position is that there is no waiver because all of the challenges were made. Why is that so?
Okay, well, first of all, I would like to back up because I don't think that's a waiver argument. I think it's a preservation argument in disguise. Okay, I don't think that's a waiver at all. A challenge, waiver would mean you waived your challenge to the juror. That didn't happen. A challenge was made. A challenge for cause was made. A challenge for cause was made because of the relationship between the juror and one of the district attorneys in the El Paso County District Attorney's office.
But if I understand the Attorney General's argument accurately, they're saying there's still a waiver because the defense had the opportunity to remove this juror with a peremptory challenge and didn't choose to do so. That's the part of the waiver argument I want to focus on.
Okay, well, but that's not the law. That's not what it says in Abu Natambu L. And as Justice Gabriel pointed out, the people have within their right to use their peremptories to make that. The legislature has made a choice. The legislator has made a choice that a certain group of jurors are impliedly biased, okay? And that impliedly biased jurors did not. should not serve as long as a challenge to that juror is made. That's what the statute says. That's what Abu Natambu El says. The challenge was made.
But we do have Justice Samore's dissent, Nabu Natambu El, and he would say that there was a waiver because that challenge wasn't made. Am I misreading Justice Samore?
You're not misreading what Justice Samore said, but that's the dissent.
That's
That's the dissent.
But-
And that's
but
where
the-
we are. You
but
know,
the
and if that
majority
issue
also-
wants to be revisited in the Supreme Court, so be it. But the Supreme Court has spoken on the issue, and the Supreme Court has made clear that, and I would like to take that one step further. If that is the rule, and we already have with Novotny that the automatic reversal rule doesn't apply. If you take away that and say you have to use peremptories, it makes the challenge for cause basically non-reviewable. Because if you don't get rid of that juror, you can't challenge it. And
But
so
if-
therefore,
I'm sorry.
yes, I'm
before
sorry,
you-
I'm sorry.
No,
Your
no,
Honor.
no, don't apologize. I'm interrupting you. Before you get too far afield, I'm stuck on that part.
Okay.
So, I understand. How do we reconcile that, defense counsel is entitled to use their peremptories,
Mhm.
but they're not entitled to use peremptories so that they can create the jury that they want, right? They're entitled to use it to get rid of biased jurors.
Mhm.
And so here we have a cause and counsel knows the juror is biased, makes the challenge. How do we reconcile that with, yeah, please.
Well, I think how we can reconcile is this. Counsel, I think you're putting it on, well, defense counsel must have made this choice, so set something up for appeal. That's not necessarily so. And I don't know what's going through trial counsel's mind, but I know with any trial counsel, with anybody who's tried a case, so maybe this juror is the lesser of two evils as far as who I want to challenge. I would rather have this juror, even if that.
I mean, we still have to kind of stop for fair use and things like that because this does belong to the court. Okay, but here's the thing: if you listen to what he's saying, and they're talking about these preemptive, it's where they get. I think each side got 16 strikes out of this pool of juries about people that they automatically struck before they even, got to much further into the voir dire there, or the voir dire. I don't even want to say it, but what happens is like in this case, there was alternates. I think there was 6 alternates. Now, they're going to start talking about something here in a minute that goes along the lines of, well, they never thought the guy would be on the jury anyway because he was an alternate. I mean, how often does somebody as an alternate get to actually decide guilt or innocent? Well, you can't really say that either. I mean, some of this argument
You never know. Yeah,
That's
that's
right.
stupid.
Yeah,
that's
some of
dumb.
this argument is like they're just stretching out as far as it can, but it all comes back to that same thing. When you're talking about in the thirds, like arm's length transactions, sort of, because it was the son-in-law of a person who worked in the district attorney's office, not the person trying the case, not the person that was helping try the case, but just a person in the district attorney's office, an assistant DA. It was their son-in-law. Okay, so that is the whole complaint here. Anyway, we'll keep watching. Just wanted to speak for a minute. There you go.
Even if that juror is impliedly biased, then juror number A over here.
So isn't that kind of what the argument around, so I've made an intentional choice to waive
Well-
my challenge on this juror?
No, I don't think it is. I don't think it is because then he would have had one more peremptory. And I realize under Novotny that that's not the argument if that juror doesn't sit. And moreover, we have to look at what happened here too. That juror wasn't on the original 12. That juror was an alternate. So, I'm not 100% sure how that because they did that off record and you can only see who was challenged, not when that challenge was made. So it wasn't a decision to put that juror on the juror. That juror could never have sat if one of those jurors wasn't excused during the trial. So we're going then even one step further, that he made a conscious decision to put that juror as an alternate, knowing that one of the jurors would then be excused sometime during that lengthy trial.
So I think it's the Novotny case where the majority says look, we don't really need to decide.
Well, that's not necessarily true because you don't
Hang on,
know
Counsel's
that one.
head about whether there's a choice.
I'm sorry. Go ahead, Sprinkle.
Well, he said that he put them on there knowing that one of those jurors may be replaced with an alternate. They don't know that one of those jurors would be replaced with an alternate. It could be that he could possibly be replaced with an alternate, but you don't know if you're going to dismiss a juror.
No, you don't.
That was kind of false what he just said.
I
Because if you
mean,
rewind it, he said knowing that one of those jurors would be replaced with an alternate.
yeah,
That's impossible to know. You can't know that.
exactly. I mean, it's just very interesting. Is it loud enough so you can hear every word? Because I'm listening. When I first listened to this, I was thinking, what's wrong with you? But then when you listen to the whole thing and you start thinking about that one person over there that is a son-in-law, he's not just the brother of the son-in-law, he's the actual son-in-law. Okay, we'll keep going.
Hmm.
It's interesting.
There's a choice, and I think it was something about like waiver wasn't really argued, and so we're not. They kind of sidestep it. I mean, here we have it before us. What, if anything, are we restricted by or have leeway to address?
I mean, I think, quite frankly, in Abu Tambuel, that's the law. And they didn't talk about waiver there, but Justice Gabriel flat out said that, the district attorney has peremptory challenges too. And if the district attorney thinks that's problematic, then perhaps the DA should use that challenge. But I think even going back one step further, everyone knew here what the challenge was and what the challenge was being made. The challenge was because of the relationship. The fact that either the district attorney or the court, quite frankly, wasn't aware of a case that's over 30 years old at that point in time, I don't think the blame should be put on the defendant. I mean, the fault here is not of the defendant. He raised the challenge. He said, I don't want that juror there because his son-in-law is working for the same district attorney that's prosecuting this case.
Counsel, let me ask another question that gets to a slightly different waiver / preservation issue. I struggled with exactly where the trial court definitively ruled on this, because the court says, well, let me think on this over the weekend. And then my recollection as a prosecutor is like, well, you could bring the juror back up and ask some more questions, which the court did. And then the court just says, okay, well, these jurors come back the next day. Why wasn't it on defense counsel to then bring it back up on Monday and say, hey, look, or Tuesday, whenever they
I don't know of a rule once you're ruled against that says you have to
Was there really a ruling?
Yes, there was a ruling.
Okay.
Yes, there was a ruling, because at the end of that day, he renewed his challenge to that juror. And in fact, the court said,
and the court just said, okay, thank you, counsel.
But what the court said when they were discussing this, and the defense counsel said his son-in-law works for the district attorney's office, the prosecutor stated in no uncertain terms, he hasn't said anything else that makes that problematic. And I don't think that being the status of the juror rises to a statutory challenge.
So you think that was the rejection of the statutory challenge?
Exactly, because the court then said, I agree that's not a statutory challenge, and I haven't heard anything else. There's a ruling. I don't know what more has to be done to make a separate rule that you have to re-raise it once you're ruled against. Once at the end of the day, when he says, I'm still objecting to juror 12, and the court says, I know, I still want him back here. I don't think you have to re-raise it. I think we can go back to and analogize this to the Bonsteel case, where there used to be this requirement that in a severance where you had to re-raise the severance motion. And they did away with that, because once you make the challenge, just like once you make the argument that the cases should be severed, you shouldn't have to re-raise it. And that's even, I would take that one step further. In that context, sometimes there's stuff that comes up in trial that makes it clear that severance should have, and you still don't need to re-raise it at that point in time. Here, it's a status argument. The status argument is his son-in-law worked for the district attorney's office. That is a statutory challenge. If there's any problem with that, perhaps one can go to the legislature and say, you don't need to make it. Maybe you can make it a presumption. Maybe you don't have to. Maybe you do something with that. That's the legislature has made a decision. The legislature has chosen that if you raise this challenge to this juror and that juror deliberates, reversal is required.
Okay.
If there are no further questions at this point in time, I will reserve.
Thank you,
Thank you.
counsel.
Mm-hmm.
All right, counsel for the appellee.
Good morning. My name is Kathy Gillespie, and I'm here on behalf of the people of the state of Colorado this morning. For time constraints, I'm not going to spend a lot of time talking about some of the specific instances I listed in my brief as far as preservation and waiver, because in reviewing the record, I found some additional facts that I just want to bring to the court's attention and then respond to some of the information that was raised in the reply brief. I think the court recognizes that the courts prior to today have all done a very good job of avoiding this issue. And even as recently as the Vigari case out of this court just a year or two ago found that where the defendant didn't exhaust all of his peremptories, a waiver was found. But in each of these cases, going back...
For interrupting a sec. That strikes me, Vigari strikes me as a common garden variety failure to preserve the issue. It doesn't strike me as particularly enlightening about what happens if all the peremptory challenges are used and whether that is a waiver. I don't think it's really helpful with that. Do you agree or disagree?
I agree, because all the peremptories weren't exhausted. My point is all the courts have kind of been able to circle this issue for various facts like that that are different. But we have multiple justices in a lot of our recent Supreme Court case law addressing the fact that this test that was set up in Novotny could create some problems. And everybody's aware and can see the train coming, but it hasn't been flatly presented. So I guess you guys are the lucky ones that get to address that today. I'm going to start with the preservation, because there are a couple things I want to point out about that quote where the court asks, what is your objection? He says his son-in-law works for Mr. Allen. And while that did talk about the relationship of the son-in-law to the DA, it was also could have been relevant to 1J. Now, at that point, maybe not, but we have to keep going. When the prosecution addresses it, he says, I hate to agree with defense counsel, referencing back juror number 8, where the fair and impartial questions weren't followed up with. But because those questions weren't asked, I don't think it rises to the level of statutory cause. Now, the defense wants this court to find that just saying statutory cause is enough to alert the court to the specific subsection. But everything in 1610-103 is a statutory cause. The only one of those that requires any fair and impartial questioning or follow-up is 1J. 1A is qualifications for a juror out of Title 13. There, the court might have to make findings about residency or physical disability. Then you have all the implied bias categories where the defendant needs to make a record that this relationship meets within the third degree of a family member. So just saying statutory cause and combining it with the statement that none of the follow-up questions were asked, really the only way that can be interpreted is the DA thought it was a 1J challenge, and it could be.
Well, counsel, when I look at the record, when defense counsel was asked about his 2 challenges for cause, juror 8 and then juror 12, and they start with juror 8. And defense counsel talks about here's what he said, and this is bias, and it's very developed around 1J factors. And then the court denies that. And
I'm going to stop for a minute for fairness. Well, let's talk about that for a minute. I mean, a lot of people are called to jury duty, and a lot of people are either police officers, wives of police officers. They work in some sort of law enforcement or attorney's office or the courthouse or whatever. What do you mean? Or why are you assuming they cannot be fair and impartial? This is wrong. I think that anybody called as a juror, when they ask them the questions, can you be fair and impartial, and just listen to the facts? If you say yes, and they assume that you're biased just because you work somewhere, I just think they're the one that's biased. And I think that's really unfortunate, because you can get rid of a lot of people who are really good jurors who really do believe that fair is fair and everybody gets a fair trial, and that you don't make decisions until you've heard all of the evidence, period. So I hate that they're having this argument about this one person and trying to get a new trial off of this one situation when she clearly said she did it. I mean, that's the strangest thing about it to me. I don't know. What do you
Hmm.
think, Sprinkle? Sounds silly, doesn't
No,
it?
I agree. I agree.
I mean, I like Gillespie, and I think she's putting on a much better argument than the other guy did. Here we go.
And then says, okay, let's talk about juror 12. And he says, yeah. And all he says is identifying the relationship. And then when the other things come, when the questioning comes up, I mean, defense counsel objected to that. When the prosecution says, you could ask him some questions. I think what he's getting at is you can rehabilitate him. And defense counsel objects.
He did, but he also objected on number 8 too, because he didn't want the trial court to go back and try to rehabilitate. His position, if you read the entire jury selection, was the record is what it is after the parties have questioned the juror. And once he makes his challenge, he objects on different occasions saying the record is what it is. And so clearly there was some confusion going on. I think then, and the court uses the same thing, I don't think it rises to statutory cause. And I didn't hear anything about a conflict or an issue. Again,
why is it still, though, not enough? I mean, defense counsel said, here's the problem. There's this relationship here. Like, I don't think they'd have to cite the section of the statute that applies.
Not necessarily.
Right? So why is that not enough?
Sorry,
No,
not
it's
necessarily the statute, but if you go to this next one where they talk about the court says he's going to bring him back, wants to think about it over the weekend, hasn't seen these facts. The defense attorney then says, I think the record is what it is. I think there's a difference between I have a son that works for the police department and I have a son that's working for a DA that is actually trying the case. Even if this was a different DA in the office, the situation would be different. That is a categorically false statement under 1B. And if you look at this court's cases in Coughlin and Ceballos, the questioning by defense, especially in Coughlin, raised two bases for a statutory challenge for cause. One was cognitive issues that the juror was having, and one was physical. So at the time the defense attorney made his challenge, there was evidence on the record and questions on the record about both. But the division was very clear that because he only challenged under the physical disability in the specific words of his challenge, the court refused to consider and basically found a waiver of the cognitive, even though if he had made it, it would have been an automatic excusal. But remember, defense counsel misses the main point of the automatic excusal. It only kicks in if a proper preservation is made.
But doesn't the court rule on both of those? It's
On
not
the-
statutory and it's not, there isn't enough of a record. No questions were asked to excuse on part J.
I'm sorry, are you talking about in my case or in
In
Coughlin?
this case.
No, the court, because I don't think the court ever made a ruling. And this is another point that I wanted to just highlight for the court. 7 different times during jury selection, this trial court said, this is too close to the line. I need to think about this for a minute. You know, it was a long, crazy jury selection that went over weeks. Each time the court took something under advisement, it came back and granted the challenge. The court was very clear that it wanted to think about it over the weekend. It did the questions. It brought both number 8 and number 12 back for April 3rd. And before they started the peremptories on 4-3, number 8 was excused. There was no reminder from the defense counsel or judge, you never ruled, nothing.
But so let me ask about that. As I understand, the contrary, like the argument we heard earlier is when the court was saying, I don't believe this is a statutory basis, that was sort of at least implicitly denying any automatic sort of issue here. And then the court went on to consider issues relating to the bias of the juror that could be remedied.
Actually, I disagree with you on that.
Okay, tell me why.
And here's why. Because he says, he talks about its statutory cause. I didn't hear anything else about there being a conflict. I don't run across these facts. I need to think about that one. And I may need to decide that next week. The questions are asked. Defense makes its objection again, or says, not the objection, but says, I think the record is what it is, and then argues a different DA in the same office would be a different scenario, which to me would tell the court I'm not arguing under 1B. And then, despite both being confused, he doesn't say anything. And here's the other thing that's interesting that I found as well. If you look on jury selection on March 22nd, right around page 39, there is a juror that comes up who is a civilian employee of the Colorado Springs Police Department. And when the trial court asks for challenges, the defense responds, he is a compensated employee of a law enforcement agency and needs to be excused under 1K. The DA had just said he's a civilian, so I don't think it's an automatic excusal. So everybody knows what requires an automatic excusal when it's raised properly. I think because he's a civilian, it's not an automatic excusal. Defense counsel corrects him, makes the argument that it's still a compensated employee. The trial court then says, give me a second, I need to look, because he wasn't sure if a civilian or a peace officer were going to be a distinction. But no fair and impartial questions were asked. The trial court took a break. I don't know if it was right away or a few minutes later, but came back and excused the juror. So it is crystal clear when you look at the entire jury selection that when defense counsel wanted to raise a specific statutory objection, as all of your cases require, and all of the Supreme Court cases in the recent past after Novotny, every single one involved a specific subsection of the statute that was raised appropriately, either by cite or by the language saying compensated employee. So I think the preservation issue is important. I think your cases have been very clear about that, as has the Supreme Court.
Counsel, can I, before you move too far forward,
Sure.
You started with sort of going into the record and saying, I've noticed some things in response to the reply brief. And I don't remember in the opening brief, and correct me if I'm wrong, point me to the right direction, where this kind of argument around, let's put it in the context of all these other jurors and other points in the record and everything like that. Did I miss that, or is that something that you are arguing today that's not in the opening? And sorry, in your answer
brief. I gave some of the citations and the statements and that kind of stuff. I don't think there was a record citation to the 7 times that process was used to kind of delay the decision and then come back and grant it. And I did not point out the 322 of the specific subsection.
Counsel, if I may,
Yes, sir.
I'd like to go to the waiver question that I asked Mr. Salmon. You have several different approaches to waiver, but the one I want to talk about is Justice Samour's dissent in Abu Natambu L. Now, it is clear in this case that the defense used all 16 peremptory challenges.
Correct.
And so this Vergari is not an issue. So why isn't Mr. Samler right that once you use all 16 challenges, that you can't have a waiver, because that would interfere with counsel's ability to make decisions about who counsel wants on the jury?
Because the case law has been clear that using peremptories to fix the set jury is not a constitutional right that's protected. Those are peremptories are given by state law. And I think it's interesting that Mr. Samler brings up, well, he was in an alternate seat, and there may have been other jurors that were the lesser of two evils. And I think in this type of case, the Supreme Court in the dissent and some of the other comments from Justices Gabriel and Hood talk about the lack of using that peremptory should be enough. I think we have way more in this case. And when you look at when the alternate was seated, I think it was very much a strategy decision. They used peremptories to excuse every single denied challenge for cause that was in the presumptive deliberating seats. The only 2 prior challenges they did not excuse were in the alternates. So I think counsel made a strategic choice, left him on. Then we get to the alternate. And when you look
Wait,
at,
I'm sorry.
sorry,
When you say that, do you mean that they used all of their peremptories on prior denied challenges for cause, but these 2 were outside of the presumptive box
correct, they only used 7 of the 16.
on prior causes?
Correct, but they got rid of all, and then they used the other 9 that go to other jurors.
Okay.
And then if you look at the juror that is dismissed mid-trial for knowing a passing relationship with the firearms expert and didn't realize it until she took the stand. When you look at what that juror says, when they bring her in to ask if it's going to cause her to be fair and impartial, she would give you the perfect answer. It's my constitutional duty. I'm looking forward to it. I want to stay. I can absolutely be fair and impartial. He dismissed her, asked for her to be removed, knowing that this juror was then going to slide into a deliberating spot. And again, he didn't raise it. He didn't ask for another peremptory. Couldn't have asked for another peremptory at that point, but he didn't in the beginning either. And he didn't say to the court, despite saying we have 6 alternates to choose from, he allowed that juror to slide in, didn't re-raise. You never did a formal ruling. I'm going to raise it again for the court because everybody's appeared to be
Counsel,
confused.
I'm going to interrupt you.
Oh, sorry.
Time is actually going. So doesn't that get crosswise with the majority where we're saying, look, we're getting into the defense attorney's head and why he made this decision? And it's like, everything you do in trial is strategic, but strategic for purposes of creating an automatic reversal versus strategic of I'm betting on this person is not going to be on the jury and just in the alternate position. And I have to make these choices.
But those are always the choices that they're making when we're finding waiver of various rights in any scenario. And nothing about the Supreme Court case law on these juror issues said that the waiver or even invited error is not going to be applicable. And I'm not asking this court to find waiver just on the failure to use the peremptory. I'm asking this court to find waiver from the start to the end of when this juror was discussed. All of the information as to preservation is also relevant to whether or not he waived this, knowing there was a confusion, knowing that it was structural error. If it was made properly, he chose not to do that. And I think that is the epitome of the gamesmanship that some of those justices were concerned about. And so in that scenario, then I think when there's other things on the record that establish the waiver, I think that's a fair place for the court to land when he was not clear. And when you look at your case law on previous cases, you'll see that that's in line with that as well.
Thank you.
The court doesn't have any other questions for me. No.
Okay, so hearing what Ms. Gillespie had to say and thinking about what the other appellate attorney, Mr. Sandler, said, and then thinking back about when this all took place during the trial, what does it look like to you? What do you think? Is it a case where he intentionally did not strike that juror because he wanted to make sure there was a reason to appeal, because he knew Judge Warner was Johnny on the spot and did not make mistakes and was a tough judge? What do you think, Sprinkle? Sprinkle.
I muted myself. Sorry, I was
Okay,
coughing.
it's okay. It's okay. I'm sorry, honey.
Yeah, her last statement really makes you think. Had she not said that, I would have never thought that. But when she said that, it really makes you go, could this be?
It does me too. Absolutely. Because I'm thinking back about the whole thing. I mean, I know sometimes y'all don't realize it, but I do have a really good memory. And I do remember everything about that trial. Magic, please take a picture of that and share it with us, because I would like to see it. Because, I'm never going to get a chance to go there. So Magic Star is going to be able to provide us with a picture of the memorial for Gannon. And I'm so happy. I will be happy to share that on our channel. That would be beautiful. Just a beautiful little way to think about him. Yeah. I know, Magic Star, I know. And, that's the thing. We're going to finish watching this, and then I'm going to talk about that, because that is absolutely affecting us, and it's not fair. And I need to find a way to bring this out and shut it all up and make these people leave me the hell alone. I'm over here not bothering a damn soul, just doing what I want to do. I don't talk about anybody. I don't get in the middle of anybody's crap. I'm just doing what I want to do. But anyway, let's finish watching this because I find it very interesting because he gets a chance to talk again, which is unfair. He gets the last word.
You know, look, I understand that no one wants to see this case tried again for this reason. I am mindful of that. But the record is clear, and I believe this court's hands are tied in this matter. Most of what Ms. Gillespie said was not raised in her answer brief, and obviously I did not have an opportunity to reply to that. So I believe that it's not proper at this point in time for those factual allegations to be made here with regard to what was said here, what was said there, and what was said there, because it kind of puts me in an untenable position of not being able to reply to that. But be that as it may, I would like to quote from Justice Gabriel in Bonsteel, which I think is important. He said that the assumption that any competent attorney would withhold a meritorious argument at trial in the hope of having something to argue on appeal if the trial goes badly belies reality. The reality is, as any trial attorney knows, the best way to win an appeal is to win at trial. And to assume that a trial attorney would say, okay, I want a biased juror, an impliedly biased juror on my jury, because if I lose, then I get to do this all over again. I think that belies reality. Moreover, if the juror is problematic, the prosecution could have used their peremptory on that juror. And moreover, you have a 32-year-old case that states that juror was impliedly biased and was a statutory cause. And I don't believe that anybody was confused about that.
Counsel, can you speak to the discussion we've been having around whether there was a ruling on this or whether it was never secured?
There was a ruling on it, and I don't think, he said, I tend to agree that I don't think it's a statutory cause, and I didn't hear anything else about that fact creating an issue or something else. And when Mr. Tellini said at the end of the day, I renew my challenge to 8 and 12, the court said, I understand. I'm calling them back. I don't see anywhere where you have to make still another one. He said, it's not a statutory challenge for cause. What more do we have? Do we have to keep on objecting once a ruling is made?
Mm-hmm.
I mean, the fault here is not with defense counsel. The fault here is with, quite frankly, the trial judge not knowing the law. Quite frankly, the rules here is with the DA not knowing that someone in his office can't sit on his juror. That's where the fault lies.
Listen.
And try to putting it back.
That person does not work in his office. That person has nothing to do with knowing the evidence or anything else with this case. That person is merely married to the child of somebody that works in that office. That's why I do not believe that his argument will stand, but we will see. But let's listen. I'm sorry. It just makes me angry.
Putting it back on, well, there must be waiver somewhere because he did this or he did that, or he didn't challenge this juror, or he didn't challenge that juror. The court made a ruling. The court got it wrong.
Can you also respond to the argument about where they're having the discussion and defense counsel says, okay, it would be different if I had a sudden, there's a difference between somebody saying I have a son or daughter who works for the police, then I have a son-in-law who works for the DA who's actually trying the case. And so that's where I think it becomes different, where it sounds like it's a different sort of challenge than what's being raised on appeal.
I don't think it's a different sort of challenge. Whether defense counsel was right or wrong at that point in time, the challenge being made was because of the relationship between the son-in-law and the DA. Whether that's the elected DA who's trying the case or the DA's office in general, I don't think it matters. In both situations, he's right. In both situations, even if it's just the relationship between the prosecuting DA, who happened to be the head DA, and the son-in-law and the father-in-law, he's right about that relationship. He's right. It is a challenge. It is a statutory challenge based upon the relationship. The fact that the trial court didn't know the law is on the trial court. The fact that the DA didn't know the law is on the DA. It's not on defense counsel. trial court was very clear that he didn't think the relationship in it of itself raised to a statutory cause. He was wrong.
Ooh, telling him
And
he's
that-
wrong.
And that's where we
Wow.
are. And I think this court has to do what it has to do and reverse the conviction. Thank you.
Thank you, counsel. Thank you to both counsel today for your excellent arguments and your briefs.
Okay.
It will be very helpful for us as we work through this case. The case.
All right, so that is the end of that. Let's get that off of there. All right. Let me close down some of these because I got a bunch of things open over here. Attorney argues. Let me see what this one is. Oops, sorry. Let me get over here. Let me just get rid of all these and then we'll talk about this for a minute because I got a lot of little things open over here. I was looking for all this stuff. All right, good. We're not sharing. Okay, good. There we are. So yeah, I mean, this is a very interesting appeal. And even though they had all these three things that they just said what the appeal was about, it really all comes down to the only thing that they could talk about is that juror, and that's it. And I think it's going to be irrelevant. And him saying that Judge Warner does not know the law? Are you kidding me? Wow. That's crazy. Judge Warner knows the law. Don't blame it on the judge. I really think it was a strategic move by the attorney. But who am I, right? It just seems like it was very strategic. Yeah. So, Sprinkle, what do you think?
Yeah, that was a very unprofessional statement to make. Very unprofessional statement to make. I think he lost a lot of credibility saying that myself.
Me too. Now, it takes about 30 days before we'll actually hear. I will be checking now that I know this has happened. I will be checking daily to see if the opinion has been published or not. As soon as it's published, we're going to put it out there. You know, Magic, I thought about that, but I can't call anybody. They're not going to talk me. They'll just let me get on. They'll let me get on the panel and they'll ridicule me just like they did Julie Skolnick. They'll do the same thing to me. I'm not going to do that to myself, you know. I don't really know what to do other than to maybe go ahead and put out the clips of the person who did this really admitting that belonged to her, that was all on her in order to shut it down. But I don't want, my problem is I don't want to start a bunch of bullshit because I'm not interested in all that. I just want to do my channel, talk about what I want to talk about and not bother anybody. I mean, I'm not a hateful person. I've never said anything mean about any of these people, and I'm not going to do it. I mean, even though they've doxed me, shown my house and all that, I mean, whatever. Hey, I took the stance of, well, if you really want to know about my house, I'll just go and film the whole thing and show it to you. How about that? I mean, I'm just me. I'm not pretending to be anybody else. I'm just doing what I'm doing just the way I want to do it. And I'm not going to hurt anybody's feelings. I'm not going to take advantage of anybody, I just don't want to do. I just think the only thing I can do at this point is put out the clips and just say, if you don't want to know the truth, this is it right here. If you got any questions, you can contact me. If not, keep my name out of your mouth, and that's that. Right? I'm just tired of my channel being hit like this. This is Letecia Stauch, okay? This is a big case. A lot of people have always been in to know about Letecia Stauch. We know that. Magic Star, we've seen that all over the place. Sprinkle, you've seen that all over the place. We've been in many chats where they talked about, and a lot of people would come in. But we've got this problem over here with this bullshit that's being brought out once again by people who never even asked me. Never.
Yeah.
They never asked me one time. So here we are with this. So I'm just gonna, I went to Dave Center's chat today. The only paid membership that I have in chats is Center. That's the only paid, because I kind of like him. He's very forward. He's very, So today he was talking about something in his chat that I was very excited about, and it was the fact that he was going to help some of these younger YouTube channels, who's going to help us learn some things about how to do this. And I'm very excited, and I'll be happy to listen. So, and I told him that I would put his name in my chat. I would drop his channel, and I will, because I think that he can maybe help me maybe maneuver around some of this, because he's been through hell and back with these people. He knows how it goes, right? I don't know that. I think that's all I really can do is keep doing that. And I guess just keep doing that. I don't know. That's just something I wanted to talk about for a second. It really should not even be on my channel. I really shouldn't even be talking about it. But after talking about Letecia Stauch and her appeal, a much weighted Everybody's wanting to wait and want to hear it, want to hear it, want to hear it. Here we are hearing it, and look at this. Look at this. So you tell me, guys, you tell me. Whatever it is, I'm not going to quit. You're not going to make me quit. I don't care what you say. I'm not quitting. I'm going to keep doing what I'm doing. And no, I've never intentionally said anything bad about any of them on a live. I have never made fun of anybody's abuse. I've never talked about anybody's abuse, and I never would. Never. Because I know that that is no place, that's not for me to talk about, period. I think that people have been in DV violence, people have lived through that and made it out, and they're still alive. They deserve a special treat. They deserve special treatment because a lot of people don't make it out alive. In fact, most of them end up dead before they can get help, and I know that. I worked in the women's shelter. I know exactly how that works. And the people that need to be hard on it are the people that actually started it, and that was whoever clipped it from Justin's live, because that's where it actually came from. I'll say it again. I'll say it forever. I've got proof. I was on a boat with my sister and did not have internet. Period. That's it. So anyway, I thought this was very interesting. We'll have to come back and talk about something. I'm sorry, Sprinkles. I got all sidetracked. You were going to show me something. What were you going to show me? Yeah. You know
Okay,
what,
I'm just
Magic?
going to read it.
Okay, go ahead. Go ahead.
I'm
What is
just
it?
going to read it. It just said it came out 4 hours ago.
What came out
A this story or whatever. A
about?
Palmdale woman has filed court papers again, seeking resentencing in a connection with her guilty plea to the first-degree murder of her 8-year-old son, who was routinely beaten, starved,
Oh,
and forced to sleep in a closet and tortured until his death more than a dozen years ago.
God.
Pearl Cynthia Fernandez was
Okay.
sentenced in March 2018 to life in prison without the possibility of parole for the May 2013 killing of her son Gabriel, but has filed
Gabriel? Okay.
but has filed 2 resentencing petitions contending that she could now not be convicted of murder because of recent changes in state law that affect defendants in some cases. Her boyfriend, Izaro Aguirre, now 45, was sentenced to death. His automatic appeal to the Supreme Court is pending. Los Angeles County Superior Judge George Lummy denied Fernandez's first petition in 2021. He said then that he carefully reviewed her petition for resentencing along with the overall record of the case and concluded she is not entitled to resentencing relief. It has been established by her own admission during her guilty plea that the murder was intentional and involved the infliction of torture over a period of several months. The judge said nothing that the record supports the theory that Fernandez was a major participant in the murder of a child victim. The judge also noted that Fernandez agreed to waive any and all of her appellate rights at the time of her February 2018 guilty plea. A March 30th hearing is set in downtown LA courtroom on the newest petition filed this week by Fernandez that alleges the state-appointed defense attorney provided ineffective assistance of counsel and coerced me into signing a plea deal for a sentence of life without the possibility of parole. Fernandez noted that she had received assistance with the new petition, which alleges that the petitioner has comprehension issues and documented verbal comprehension of a second-grade student, and she was mistakenly under the impression that her case would be going to appeal when she signed the plea agreement. Prosecutor John Hatami, who opposed Fernandez's initial bid for resentencing, told City News Service that he again will fight to make sure this does not happen. The repeated requests to be resentenced are unfair and unjust to Gabriel. Gabriel's family, his siblings, and our LA community, he said. Having to continually relive these events and trauma for the family is not humane. At some point in the criminal justice process, we must stand up for the victims and for justice. So as long as I'm around on this planet, I will continue to do my part to make sure Gabriel receives justice and is never forgotten. Fernandez committed one of the most heinous crimes ever in LA County against an innocent child.
That's so sickening. We need to keep up with
Yeah.
that. Sprinkle, let's keep up with
Yeah.
that. Let's see if we can get our
March
hands on any of the documents. I'll try. I mean,
March 30th. It's supposed to go
okay.
to court.
Okay. We'll try to get the appeals documents and stuff. The reason why we don't have Leticia's, and I don't know how this other person got these, is because they are sealed. So I don't know how she got her hands on this, but those documents are sealed. I have done every kind of request I can do to get those documents, and because they were sealed, they would not give them to me. Okay, so that's neither here nor there. Maybe we can get the other ones on this case, because when you read the briefs and the appeals, you find out all the information that you didn't hear before because you are not in the courtroom when this is being discussed. Because what you're seeing when you see little clips on TV or whatever, they're not showing you the whole thing, and I don't think that the Fernandez trial was even televised. So I think we are to get that brief and we are to talk about that and just read it, just go over it, because that's what I kind of like to do is talk about past cases and things like that. But yeah, that's wonderful. Thank you for sharing. You're right, Magic.
Of
I did
all the
allow that. Go ahead.
of all the cases that I've seen, that one really hit me the worst. I could not watch. I
It was
started to watch
horrible.
the documentary. I couldn't
hmm
finish it. I got through just
hmm
a very little bit of it and I could not watch the rest of it. I could not. It just affected me so bad. I don't know why. I don't know if it's because I'm a mama boy.
Mama
I don't
boys,
know
yeah,
why.
yeah.
I don't know what it was, but I could not watch. I couldn't watch it.
Mm-mm. Well, we're gonna stay on top of that one because I do want to know more about that. I can't believe that she's
Yeah.
done this. I mean, they
Yeah.
asked her in
It
court,
just
"Do you understand that you cannot appeal your case because you signed a plea agreement?" And she stood there and said, "Yes." What do you mean she didn't understand?
uh-huh. Yeah, she didn't understand
Golly.
because she has a verbal comprehension of a second grade student. Well, I don't think a second grade student could abuse anybody the way that she abused her child.
No,
So she must
hell
have a little
no.
bit, she has a little bit more comprehension than a second grade student.
Yeah, I agree with you on that. That's crazy. That makes me sick.
Yeah.
That makes me sick.
Yeah, I came
Mm,
across it and there was a couple articles that were like 4 hours ago, 4 hours ago, and I was like, what?
mm, damn it. Well, we're not going to stay on long. I know you've been up since 4 o'clock this morning and you're tired. I know it. And yeah, Magic Star, I absolutely did. Yeah, I'll tell you, oh, Gabby made me sad too, but Gabriel Fernandez is one that tore me up. I know it's one of the saddest. It was kind of like this, like Gannon. It was just horrible, absolutely horrible. I
Yeah.
can't believe it. Do you know
What
what
they
it's
did to
on?
that boy was
Um,
just,
well, March the
I think
30th
they're
is going
still
to be the appeal.
March,
Yeah,
yeah,
yeah.
March the 30th.
Let me see.
Yeah, I
I
think
think
they're
you can
still
still go watch
playing
this. Yeah, yeah.
Gabriel's story on Netflix. I think it's still on
Let me
there.
see if I can find something over here on Gabriel Fernandez. But what I was going to say is, remember Magic Star after I let you come on and talk and you did a beautiful job, then I had somebody else that wanted to do it and they came on. But after we had done the live show, she'd contact me and said, I really kind of felt uncomfortable. I said, no problem. I took it down because you know what's more important to me? How you feel, not how I feel. Because I will never, ever. Oh, no, there is a documentary about Gannon, but it's on a pay station. It's on Crime. It's on Crime Prime. I think it's called Crime Prime. I tried to get it today and watch it, but they want you to pay $16.99 a month. It's just ridiculous. So I'm trying to find a different way to get that because it's on a series. It's called something murder something. Let me see if I can find it again. Hang on. Whoops, I didn't mean to get out of that. Hang on a second. I was looking it up a while ago. It's called Murder Something, and it was just one of the. I'll find it. I'll put it on my community page. Yeah, yeah. You remember that? Because I did. I told her. I said I will never ever leave something up for money or clicks or likes. If you're uncomfortable, that's fine. I'll take it down. I'm just not like that. I'm not going to hurt anybody. I don't want to hurt anybody, and I don't want anybody hurting me. That's how I kind of feel about it. And I told Magic that we wouldn't stay long. I mean, I'm sorry, Magic. Sprinkle, because she's been up since 4 o'clock this morning. I know
I'm
she's
okay.
tired.
I'm doing okay.
Okay, yeah, I did put her trauma response before my channel because I understand the trauma response and how it affects you your entire life. It doesn't matter if you were 5 years old or 25 years old. That trauma response sticks with you forever, and little things can
Yeah.
trigger it. And I would never trigger anybody to have that come back, have that, some kind of a panic attack or have, the things that happen in trauma responses because it's horrible.
Yeah,
You
and
know,
you never know what will trigger it. You never know when
right?
it will be triggered.
I mean, people like to talk about what's happened to them and they feel better if they talk about it. But sometimes just talking about it can re-trigger something. That I don't want that to happen to anybody. It's hard for me to come on and talk about children that have passed away. It's hard for Sprinkle, you know, because we've both been there. But I find that if I talk about it and I let other people talk about, if we form a bond through that and we talk about it, we feel better because we have somebody that we can talk to that doesn't judge us because they've been there too, right?
Yeah, and you
Because
feel
there's,
like you're not
yeah,
alone. You feel like you're
right.
not
You're not
alone.
alone. And I always tell people to, you're never alone. You ever want to come up and talk about something? Let me know. Call me. I don't care. Whatever. You do whatever
Well,
you
and you
need to
feel
do.
stuff that you wonder, like, should I be feeling this? Is this normal to
Yeah.
feel this way? Is it
Right.
normal to
Right.
not feel this way? Why don't I feel this way? Why am I not feeling that way? Why, there's so much questions to it. You don't
Yeah.
know.
Right. I mean, because and you wondered yourself, do other people feel this way? Well, you don't know unless you,
Exactly.
yeah, yeah. Also, shame and embarrassment can be a very unfortunate side effect of the trauma. Yeah, it is. Because even though we didn't do anything wrong, we feel like maybe we did something because that's kind of how when it first happens, that's how people make you feel. I mean, that's just I remember all that. I remember, oh my goodness. You know, yeah, it's so sensitive. It's so sensitive. And here's
And
another
people
thing.
say the stupidest thing. They don't, and rather than just saying, I don't know what to say, they just say
Uh-huh.
stupid stuff. They just say
Right. And
stupid
it
stuff.
is because they don't know what to say. Yeah.
Hmm.
Yeah.
Yeah. And rather than
Right.
just saying, you know what, I really don't know what to say, and say nothing. They just come up with, well, you should be glad you finally got out of that situation, or you should be,
Right.
whatever.
Right.
Especially in DV, there's so many things that people say. Well, if it was me, I would have never let that happen to
But
me. Well, you don't know until you're in the middle
that's
of a
right.
situation how you're going to react
That's
in any
exactly why.
situation.
Yeah.
Hmm.
And she's right. Magistrate's right. Why did you stay? I would have left. Well, people always say that, but what they don't
Hmm.
understand about these women,
Yeah.
because it was hard for me when I first started working with these women. And then I finally realized, oh my God, that a
Yeah.
lot of them, when they finally do get to leave, they leave with the clothes on their back and their children, and that's it. And they never go
Hmm.
back to getting any of their belongings. They're just gone because they know if they go back, that asshole's going to take their life. And it could be a
Yeah.
man or it could be a woman that's a survivor of this and that is, this in this situation. I mean, and no, people do not understand that some people, when they're in this situation and they realize I have 3 or 4 children, I have no education, I can't get a job, I need financial help. If I walk out that door, he's not going to help me, right? I mean, it's kind of like this mental, and there's no way to go and get the help before you walk out the door. That's the sad part.
Right.
There needs to be some
Right.
kind of um, help for people that are planning to walk out the door from this as being a survivor of DV. They need the help before, not after, because
Hmm.
they by that time they know if they go back, they're gone. They're not going to be able to survive. They have to go in hiding because the man's looking for them. It's horrible, or the woman, whoever. It could be either sex. Anyway, it is horrible. And it's so hard, and people don't listen. People don't listen when people try to explain to them how this happened and where they are in the situation. People just kind of turn it off with, well, I would have left a long time ago. No, you wouldn't
Yeah.
have.
But
Shut that
people
shit up.
don't realize but
Yeah,
people don't realize being in the situation like that, how it changes the person that you were
right.
before you became a victim of domestic violence. You might have said the same thing, but being in
Right.
the midst of a domestic violence situation, your whole being is changed. You're not who you were. You're not the
That's
same
right.
person. You are different. So
I
your
mean,
responses are going to be very different than what you think your responses were going to be before you got into that situation.
that's right. I know you're right about that.
You're
Like
you're
um,
totally different.
being a survivor of domestic violence, you also go through, and this you go through like a grieving period because I mean, every time you are married and divorced, you have this grieving situation that you do. And it just like, because it is the death of a relationship. It is the death of something you're never going to have back. It's the death of something that started out so beautiful, but turned into what it was by the time you finally got out. So there's a grieving process that goes along with this that people don't even think about. They don't realize that's happening to you. Yeah, you don't even recognize yourself anymore. I mean, mine was not domestic violence, but the trauma was the losing my child. I'm not the same. Never. I will never be the same. Never. And when Magic came up, when Magic Star came up and she did a live with me, and it had a lot of views. I was so proud of it, because people really listened. They wanted to hear the story. I think when we talk about these things in the way that she talked about it, it gives people information, and it gives them hope that maybe they could walk out too, or maybe that they will find a way to change their situation as well. So, it's a beautiful thing. Thank you, Magic Star. I love Magic Star. I've always loved her. Her and I've been together for a while now, but out of a situation, but that's okay. I still love her. She it's like, once we gain friendships like that, it's the kind of friendship that it doesn't matter if I didn't talk to you for 3 weeks. When I do talk to you, it's like we never missed a step. It's like we never missed a day. And it's because we bond from the trauma that's happened to us. And that's a good thing. That's a beautiful thing. You need that person. You need people that you can discuss your problem. You can discuss it with, who don't judge you, who don't talk about you afterwards, who don't treat you like you're less than them because they've never been there, that kind of thing. And it happens to people. And it just makes me so sad when I hear these things and I see these things out of people. And I'm thinking to myself, if any one of those people ever spent 5 minutes in a shelter with these women, they might think differently when they saw the damage. You're talking about women that come in there literally with their children, the shirt on their back, and they're beat up. They've been to the hospital. They look like hell. They've got stitches. They're scared to death. They don't want anybody coming close to them because of their fear. Their children are scared to death. Their children are in the corner crying. The children are lost. They don't know what to do. The children need a lot of help. They need to have a lot of counseling out of it, because if you don't get them counseling, they're not going to know what to do to protect themselves so that they don't make some of the same mistakes, because you don't realize something's going to happen to you until it's too late, because they groomed you. The whole time they groomed you.
It's not even fear, it's terror,
Yeah, it is terror. Yeah, you can't even go to sleep at night because you're afraid. Think about that. That happens to people. But they're afraid the minute the man walks in the door, he's going to be drunk and beat the shit out of them again. Even though they cooked supper, cleaned the whole house, taking care of the children, everything's done. And they're just, trying to wait on their man to come, whatever, or their wife. It could be the husband or the wife. And then they don't know if the man's going to walk in and beat the shit out of them or be happy they cooked dinner. You just don't know. Everything's so volatile. You can't live your life walking on eggshells. But until somebody helps you learn how not to, you're going to do it. It's just the beast that it is, So, and I hate that. How many people?
It's terrible.
Think about, and then think about all of these children who grow up in this situation. They don't ever really get the proper help, and then they turn into the same beast because that's how they were raised. That's what they saw. They don't know different, and that's a sad thing too. That generational trauma. It's terrible, just terrible. I know we go from one thing to another. Ain't that funny how we get on one subject, we end up on another one, but that's okay. It's okay.
That's what we do. That's what we do.
We do. The thing about my channel is I always wanted it to be like we were all just having a cup of coffee together, just talking. I didn't ever want to do that, strict. We're only going to talk about this thing and that's it. We're not going to get off topic. I don't want to do that to people, because this is a place where we can all say what we want to say, think what we want to think, share our experiences, and we don't and not judge each other. And it's okay if we don't think the same on things. We're not supposed to. If we all thought the same thing all the time, then we would just be very boring people, wouldn't we? I like to hear other people's opinions. I like to hear about somebody tell me about something we may be talking about and show me a different way because I didn't think of it that way. I like it, Yeah, it was relevant to address some. Thank you so much, Magic. Thank you. It just, I wasn't going to talk about that right now, but I'm watching this live and we're talking about Letecia Stauch, the monster from hell, that a lot of us have made very harsh references about and said, God, when her appeal comes up, I want to know about it. I want to know about it. I want to know about it. And here we are. We're discussing it. We're showing it. And here we are. So anyway, well, I guess we're going to probably get off of here. I know you've been up since 4 o'clock in the morning. I'm kind of tired and my throat's starting to get sore. I think I'm getting sick.
Oh,
I hate
no.
to admit it.
Oh,
I think
no.
I'm getting sick.
Vitamin C, vitamin C.
I need to do that. I do. And then, of course, I have so I'm actually going to see the actual surgeon on Tuesday for my damn hip problem. Now,
Oh, are you?
yeah, I mean, I went to the first doctor, but he's not the actual surgeon. Okay, here's how it goes. This is crazy. But, okay, so, I have the fusion in my back with screws and all that. So I'm making my appointment to go to the orthopedic, and I'm telling, well, I need to see the hip doctor, blah, blah, blah. And they were like, well, what portion was your MRI on? And I said, well, I have an MRI on my back and an MRI on my hip, right? Because they wanted to look it up. Well, so I go, and they make my appointment, they put me over with a spine doctor. You got a sore throat
Oh,
too?
Jesus.
Oh, no.
Oh, God.
So they put me with a spine doctor. I'm sitting there, I'm going, well, I'm trying to get the readings from my MRI and discuss what we can do about my hip. He goes, I do the spine, I don't do the hip, but I'm going to refer you over here, blah, blah, blah. His partner who does the hip, but he's over in Cedar Park and I'm over here, in Austin. So he goes, we'll just get you an appointment over there, but I'm going to go ahead and give you your readings and tell you what's wrong with your hip. And then he can tell you what to do about it. But in that same sentence, he's telling me, well, now people your age, we don't just fix it. We replace your hip. I'm like, what the hell? I know
Oh,
we kind of
wow.
talking about this. Yeah, we kind of, and he goes, and I said, what do you mean my age? He goes, well, anybody over 60, because really they don't heal very well. And I'm looking at him going, I am a perfectly healthy person other than my back and my hip. If I didn't have these two problems right here, I'd be running a damn marathon. I am healthy. What are you talking about? He goes, well, that's just how they do it. I'm like, he goes, but talk to the hip surgeon. I said, okay. So I told my husband, I said, well, I'm going to go see the hip surgeon on Tuesday. And he goes, well, are you going to do a hip replacement? I said, no, I don't want to do that. I mean, why would I do that? That's extreme. I mean, it makes no sense. So
Yeah.
we'll find out on Tuesday what's the real deal. I don't know if that guy was just talking out his ass or just thinking that, well, you're 65, so that's the answer. I don't know, because it sounded
Yeah,
crazy
no.
shit to me. That's like the pain management doctor telling everybody, oh, get that stimulator. Every time you go in there, you got to get that stimulator because they make a lot of money off it. I'm like, I don't want that stimulator.
Oh,
I'm
yeah.
not doing that. Yeah, you know what I'm talking about.
Yeah.
They told you the same thing? Get that stimulator.
Oh, yeah. There's so much money in healthcare. It's stupid.
Yeah, it is ridiculous. So
I'm a firm believer that's why there's no cure for cancer, because cancer makes so much money.
right. You know what? Some person could have taken the life of somebody who would have had the cure for cancer, which makes me sick.
Yeah.
A lot of Gannon was a very smart child. We know that Sebastian Rogers is a very smart child. I mean, there's a lot of these little kids that had their life taken that were very smart, For our friends in the bushes, kindly hit that like button. Thank you so much for being here. Yes, thank you. And if you come in and watch it on replay crew, which I love, that's fine. Please hit that button. We need to get this out there to the algorithm, because I don't know. Anyway, okay. Well, we'll just talk about something else later. I am going to do a live on Monday if I'm not sick, and it's going to be about the Bible. I know you're going, what? The Bible? There's no money in cures. You're absolutely right about that. So I'm going to tell you what this Bible thing is about. It is about things that they are saying is in the Bible. When you go onto these little channels that you know what I'm talking about, the false prophets, and they talk about all these things. Oh, it's in the Bible. No, it's not in the Bible. It's not in the Bible. Stop saying that. So anyway, that's what it's going to be about. It's going to be kind of interesting. And I know that it's not for everyone. I get that. But it's just something that I feel passionate about and that I want to talk about. So, yeah. You believe that with your entire soul? That's right. I do too. Because there is no money in it. They don't make, everything's driven by money, which sucks. It really does.
Mm-hmm.
It's sad. It really is. But that's what kind of went, it's not love that makes the world go round. It's freaking money that makes the world go round. Think about that. The televangelist. Thank you, Magic Star. Yes, it's going to be an interesting show. And yes, I'm going to bring up the false prophet that you all know I just can't stand to listen to her bullshit. I'm going to bring her back up. I haven't talked about her in a while because she's part of the problem. But anyway, you all have a good evening. Thank you for stopping by. We always appreciate seeing you guys. It's always so fun to have discussions. I always say, take care of yourself, be careful out there, and sprinkle your turn.
Hug your babies.
That's damn right. You get time with them is short. You know, they grow up fast. Anyway, y'all have a good evening. Take care of yourself. Go get some salt water and gargle salt water magic. It'll help you feel better. Okay, see y'all later.
Yeah. All right. Night, everybody.